All rise.
Further hearing in the appeals, Martin and Her Majesty's Advocate and the Advocate General for Scotland, and Miller and the Procurator Fiscal.
If I could pick up on one or two points that were raised with me yesterday before returning to the Scotland Act, could I invite my Lords to have before them Volume 6?
Of the authorities.
Of the authorities, yes. Thank you, my Lord. And if I could ask my Lords to go to tab 82, where my Lords will find a print of the 2007 Act, and I'm going to look at the points that were raised yesterday in relation to the provisions starting on page 47 of that print.
Tab number, sorry? Tab 82.
Tab 82 at 47.
Yes. So this is the 2007
It's the 2007 Act.
Yes.
My Lord and the Chair raised with me the question of section 45(3) yesterday. And I'm told that that provision has not in fact been operated.
Not yet, anyway.
Well, not yet, no, my Lord. What, of course, is significant is that that provision relates only to relevant penalty provisions and relevant offences being those which are triable either way.
Yes.
And the maximum term which can be appointed under this provision is 12 months.
But I mean, they could have used that to adjust the 1988 Act, is that it?
It could have been done, my Lord, but
I mean,
in fact,
just to tidy it up. I mean, you don't need to because it's already there in 45(1), is that it?
well, indeed, my Lord, and I think we saw in the background papers that the explanation for that provision was with a view to tidying up.
Yeah.
Am I right in thinking that there are other statutes, UK statutes, that have either way provisions similar to the Road Traffic Offenders Act?
Oh, yes.
It's not unique.
Oh, not at all, my Lord. There are many statutes which have either way provisions. There are some examples which are given in, I think in my case, at various points of both reserved and non-reserved statutes, UK statutes and Acts of the Scottish Parliament, which create either way offences. It's far from particular to the Road Traffic Act, and indeed in my submission it is important when my Lords are considering the purpose of these provisions that the natural focus that arises from the fact that we're dealing with a road traffic offence and a particular road traffic offence should not distract one from the generality of the offence of the provision that's been created here.
What branch of the definition of criminal law in section 126, subsection 5 of the Scotland Act are we actually dealing with here? You'll see that subsection 5 says that references in this Act of Scots criminal law include, and there's a series of aspects of the criminal law which are mentioned. It's a pretty inclusive definition, but which of these would you say is really the more appropriate of the chapters that are listed there?
I think if one had to choose one, I suspect it would be penalties, although it might also be said to be an aspect of jurisdiction.
Or procedure.
Or indeed procedure. And in my submission, the definition does not require one to select any particular item from the list.
But it does help. I mean, it may be important in a way for trying to understand what the purpose is and whether this is a special provision or whether it's a general provision. These are things one's having to consider when you go back over Section 29 in the schedule. If it's penalties, that's rather specific, but I rather thought the McInnes report was looking at aspects of procedure and jurisdiction.
Well, that's true, my lord, and perhaps I could yes, this provision certainly deals with jurisdiction, and it deals with procedure, and I have to accept it's dealing with penalties, but it's dealing with not with the penalty for a particular offence, but the penalty available in a particular mode of trial, which might be seen to be...
And it's not attempting, as we saw, although there's a risk of sentence drift, it's not the aim of the thing to affect sentence levels. It's more concerned with the procedure under which the judge, or the sheriff, I should say, determines the penalty.
It is. It's about a reallocation of business.
Yes, thank you.
But I would I hope it's not unhelpful to say that I would resist the view that a particular provision necessarily has to be particularly characterised under one of the heads. The point is that 1265 is plainly intended to be a broad and all-encompassing provision.
Yeah. Well, that was the first point I think you were going to mention, Section 45.3.
Yes. My Lord asked me about the provisions in relation to fines, which are at Section 47 and 48. Now, perhaps taking them in reverse order, Section 48 has to be read along with Section 225 of the Criminal Procedure Scotland Act 1995, and I hope that a copy of that has now been made available, or will be being made available to my lords in a moment.
Okay.
And my lords will see, reading Section 48 of the 2007 Act with that provision, that the effect is to increase the prescribed sum from £5,000 to £10,000. Now, the prescribed sum is a term which is used in Section 5 of the Act, which my lords have in tab 78 of the same, Section 5 of the 1995 Act,
yes,
which my lords have in the same volume of tab 78.
And do we look at the amended version of Section 5?
If one's looking to see what it is the 2007 Act has, well, for this purpose it may not matter, because the important point is that 5.2 The Sheriff shall, without prejudice to any other or wider powers conferred by statute, have power on convicting any person of a common law offence to impose a fine not exceeding the prescribed sum.
Yes.
And so that 48 is the equivalent in relation to monetary penalties of section 43. And so far as turning then to section 47, what that provision does is that it in effect mirrors section 45 by telling us that the maximum fine to which a person is liable on summary conviction of a relevant offence is, by virtue of this subsection, the statutory maximum. And by dint of a process going via the relevant interpretation legislation, the statutory maximum is to be read as referring to the prescribed sum in section 2258.
And what is this telling us about section 45? I'm not quite clear.
I think the point is simply this, my lord, that the provisions in relation to sentence of imprisonment is mirrored in provisions relating to the imposition of fines.
47 deal with both offences which are triable only summarily.
No.
And either way one.
No, my lord, because they're only concerned with relevant offences, and my lord will see in 47(6) that a relevant offence is
Triable either indictment or
triable either way, and punishable with a maximum fine specified as level 5 when punished summarily. Right. So it's in effect uprating from level 5 to the statutory maximum.
And that will be for statutes that are acts of the Scottish Parliament as well as United Kingdom statutes.
Indeed, my lord.
Yes.
My lords also asked me some questions about the JP court and the constitution of which is provided for in part 4 of the Act. The jurisdiction of the JP court is dealt with in the schedule to the Act, schedule to the 2007 Act at page 90 of this, the print that is in tab 82, paragraph 9.
Page 90, did you say?
Page 90 of the print at tab 82. And what that provision does is it amends various sections of the 95 Act, which are in tab 78, and in effect simply apply to the JP court the jurisdiction of the district court, which my lords will see in section 7 of the 95 Act involves a maximum period of imprisonment of 60 days.
Well, that tends to reinforce the point that we're really dealing here with a very major readjustment of jurisdictions. Is that not right in the Scottish system? Well,
as far as the JP court is concerned, there's no change in the jurisdiction vis-à-vis the district court. That reform is, as I understand it, carried out for other reasons to do with the creation of a unified court structure.
Right.
Rather than...
But the overall scheme is reorganisation of criminal justice as applied in Scotland.
Indeed, my lord. And it does, these provisions do reinforce that aspect of it. I should say that the jurisdiction, I'm told the section 103(1)(b) would not be prosecutable in the JP court or the district court. But there is an interesting effect of the creation of the JP court, which is, if one goes to section 10 of the Road Traffic Offenders Act, which my lords have in volume 8 at tab 104.
Yes. Section 10.
Section 10. My Lords will see, notwithstanding anything in any enactment or rule of law to the contrary, a district court in Scotland may try any fixed penalty offence and another category of offence. Now, the 2007 Act substitutes the words Justice of the Peace Court for District Court.
Yeah.
And that's paragraph 7 of the Schedule 2, the 2007 Act. And I suppose perhaps I can make this point, that it would be very peculiar if, as in the context of a reform of the administration of justice in Scotland, in effect, parallel systems had to be kept in place in order to deal with different categories of offence. While my Lords have in front of them, or perhaps close to hand, section tab 78 in volume 6, I think I should just, for clarity's sake, make this point, that section 7, subsection 5 of the 1995 Act provides for the jurisdiction of a stipendiary magistrate. Now, a stipendiary magistrate sits in the district court or the JP court, but he has the jurisdiction of a sheriff.
Yeah.
He's a professional judge, and as I understand it, that particular mechanism is used only in Glasgow. While we're looking at those provisions, it may be worth noticing that the United Kingdom, in its legislation, has acknowledged Section 45 in the context of reserved matters, and there should be available to my Lords short extracts from two pieces of legislation. First of all, the UK Borders Act 2007.
How is this going to help us, Mr. Advocate?
Well, it's simply, and of course it's entirely consistent with the Advocate General's position, that the United Kingdom plainly has no difficulty with the notion that this provision applies to reserved matters. And it perhaps suffices just to notice in the UK Borders Act 2007, section 42(5), where a maximum sentence is imposed. But only until Section 45 of the 2007 Act is commenced.
So that's 42, yes, 42(5)(c).
Yes. Just again on some matters of information which were raised with me yesterday. On the question of statistics, my Lords, a question had been asked in relation to the cases which in the summary courts have resulted in a sentence of more than 6 months being imposed since this Act came into force. And the statistics for the period, and my Lord should recall that the Act came into force on the 10th of December 2007. The 2008-2009 statistics are still in the process of being compiled and will not be available until, I'm told, until March of next year. And for the period from December 07 to March 08, for which statistics might have been expected to be available, apparently the sentences over 6 months were coded in the system wrongly as, in effect, proceedings on indictment, because the statisticians had not caught up with the legislative change. So that's the reason why I'm afraid I have no hard information to provide to my Lord Rodger in particular, I think, who raised that point. So far as the question of the Sentencing Commission is concerned, I think I, perhaps along with others, had in mind legislation currently going through the Scottish Parliament to create a Sentencing Council.
Right.
There was a Sentencing Commission which was set up originally under the chairmanship of Lord Maclean and subsequently under the chairmanship of the late Lord McFadden in 2003, which had a remit to review and make recommendations on a variety of matters, including the scope for improving the consistency in sentencing. And indeed, it was as a result of the report of that commission that the proposals for a Sentencing Council are now before the Scottish Parliament.
So the commission, does the commission still exist?
No, it dissolved. It
dissolved.
Exhausted its remit in November 2006 and is now dissolved.
I'm sure Lord Brown would correct me if I'm wrong, but I believe the English position is that there is a Sentencing Commission and a Sentencing Council.
I believe there is too.
And they have rather different functions.
I believe the proposal is that there actually should only be one. I think that they contemplate trying to either merge or somehow unify the system.
Yes. Anyway, thank you very much. So it's a Sentencing Council that is the subject of legislation under consideration following a consultation process.
Yes. The only other point of clarification arising from yesterday is I think my Lord's asked Mr. Shedd if there had been any amendment to the relevant part of the Road Traffic Offenders Act, Section 1031B. And I would simply point, my Lords, to the print of that Act at tab 10 of Miller's core bundle, and it may not be necessary to look at it, because I simply note that the provision for penalty points had been amended.
Very encouraging to know that nothing has escaped.
Well, I would hesitate to give my Lord any assurance to that effect, but having noticed that, I thought I should draw it to my Lord's attention.
And just going back to the sentence drift problem, that you're not aware, are you, of any decision by the appeal court which would address that issue? Has anything come to their attention to suggest that there is a drift in sentencing?
I'm not, my Lord, and I should say, when I say that, I'm simply not aware. It's not something I've particularly looked for.
Very well. Can we go back into the main argument?
Scotland Act, yes. But my Lord and the Chair yesterday asked me whether there was any particular approach, I think, to be taken in relation to interpretation of this Act. And perhaps I could draw my Lord's attention to an observation of Viscount Simmons in a case involving the Government of Ireland Act. This is Belfast Corporation against OD Cars, Volume 1, tab 17. Here's some general observations to make at page 518 in the appeal cases report. .518.
Somebody's helpfully produced it back to front. It's yours back to front.
Mine seems to be all in the right order.
Yeah.
Is it just at page 518, or do we have to look more widely?
It's at page 518. It's just a short passage where, under reference to the Government of Ireland Act, Viscount Simmons, about two-thirds of the way down the page, well, perhaps I can take it from just above halfway. The point here was whether a piece of planning legislation could be, by virtue of the restrictions it imposed, be treated as taking basically taking property without compensation. And just above halfway, His Lordship says, "For my Lords, I would here point out that if such restrictions cannot be enforced without the payment of compensation, the practical effect must be to deprive the Parliament of Northern Ireland of the power to legislate, not only in this particular field, in a manner recognised as necessary to its proper fulfilment in Great Britain, but in numerous other fields also in which it has been widely realised that the rights of the individual must be subordinate to the general interest." And then a little further down, he says this: "It's right, however, that in the interpretation of constitutional instruments, guidance should be sought from those courts whose constant duty it has been to construe similar instruments, if only because, as it appears to me, a flexibility of construction is admissible in regard to such instruments, which might be rejected in construing ordinary statutes or inter partes documents." Now, my Lords, I don't particularly invite this court to look widely at decisions on other constitutional instruments, because one of the peculiarities of the Scotland Act is it tells us in section 29(3) how to go about the process of deciding whether a piece of legislation relates to a reserved matter or not. But I thought I should draw my Lord's attention to the reference to the scope for a flexibility of construction in relation to instruments of this sort.
I think there was a comment yesterday about the rather elaborate structure when one compares Section 29 and its subsections with Schedule 4
Yes.
in paragraphs 2 and 3. But is your point, well, that's all part of the process of trying to build into the system the flexibility that's needed to avoid the Scottish Parliament being too restricted in dealing with issues of the kind that are mentioned?
Indeed, my Lord, and it goes back to the point that I perhaps put rather haltingly yesterday at the outset of my submissions, that part of the purpose of this legislation is to create an effective and workable set of institutions with the capacity and power to legislate, provided, of course, that they respect properly the restrictions on their competence. And that point, which I tried to make rather haltingly yesterday, was perhaps put rather more elegantly by Lord Porter in a case which is in volume 5 at tab 62.
I mean, may we look forward at a comparatively early stage of your further submissions, Deputy, to some crystallisation of a submission on what actually is the purpose of the provision we are here concerned with?
Yes. The purpose in my submission...
Can I write it down, because it's quite important.
I appreciate that, my Lords, and perhaps I ought to have my... I say, my Lords, that the purpose of section 45 is to increase the sentencing powers...
To increase
the sentencing powers of the sheriff sitting as a court of summary jurisdiction and thereby to effect a reallocation of business within the court structure.
Within the sheriff court structure?
Within the sheriff court structure. Well, with this minor qualification, my Lord, because of course the stipendiary magistrate has the same sentencing powers.
Of course, yes.
So there is the potential in Glasgow for cases to be prosecuted using these powers before
Yes.
a stipendiary magistrate. So I think perhaps I should retain the generality of my proposition.
Right.
Do you want to add, or doesn't it matter, in respect of two-way offences, or either, whatever they're called, either-way offences? Or doesn't it matter? I mean, Section 45 is confined to either-way offences.
Section 45 is confined to either-way offences, and of course it falls to be read with Section 43, which deals with common law offences, which are necessarily also either-way offences.
But do you also want to add, irrespective of whether these are in an Act of the Scottish Parliament or a United Kingdom statute? Because there's a generality point, isn't there?
That's absolutely right, my lord.
So where's it going in, Mr. Wool? Where's it going in? Are you putting that in?
Or do you want to look first at subsection 4 and see if you need to tweak it to accommodate that?
Section 29(4).
Didn't I say that?
Subsection 4. It's section 29(4).
Sorry,
His Lordship was referring to.
I'm terribly sorry. I meant certainly 29(4).
Yes.
Did I say something different?
Yes, you said subsection 4.
Yes.
Sorry.
The purpose is to increase the sentencing powers of the sheriff sitting as a court of summary jurisdiction, or the sentencing powers of the sheriff are across the board.
No, but I mean, assume we get to subsection 4.
Yes.
You say, on the purpose you've just identified, that wouldn't otherwise relate to reserved matters, but it does make a modification of Scots criminal law as it applies to reserved matters.
Yes. And it does.
Therefore, you lose unless the purpose of the provision is to make the law in question apply consistently to reserved matters and otherwise.
Well, that's certainly part of the purpose here in my submission.
Well, you have to say that. I mean, that's the only way you escape under 4.
Well, I think there is I will make a submission to my lords that 29(4) is directed to provisions which modify the criminal law as it applies to reserved matters, but not to provisions which modify the criminal law generally. But I'm quite happy to take the fallback, if you like, that part of the purpose of this provision is to make the law apply consistently to both reserved and non-reserved matters.
Well, that's why I was raising with you the fact that on the face of it, it does appear to extend to acts of the Scottish Parliament as well. It doesn't make a distinction.
Of course.
And somewhere in the proposition, it perhaps ought to go in.
I can see that, my lord. Perhaps I should try again. The purpose of Section 45 is to increase the sentencing powers of the sheriff sitting as a court of summary jurisdiction and thereby effect a reallocation of business within the court structure, and to do so irrespective of whether the offence in question is a reserved matter or a non-reserved matter.
Is or is not a reserved matter.
Yes. Right. Well, you were going to mention Lord Porter's remarks in the case from India, is that?
Yes.
That's going to help with it.
What was an issue here was a piece of provincial legislation dealing with moneylenders and imposing a restriction on the recoverable sum. Now, the moneylenders in question had taken promissory notes and sued on the promissory notes and were met with the restriction under the provincial legislation. Promissory notes were exclusively for the Federation, and so an issue arose which was addressed by Lord Porter at pages 41 to 43. And at the bottom of page 42, His Lordship said, against the argument that as soon as you were dealing with something in the, as it were, reserved field, the legislation felt to be treated as invalid. And at the bottom of the page, His Lordship says, to take such a view is to simplify unduly the task of distinguishing the powers of divided jurisdictions. It is not possible to make so clean a cut between the powers of the various legislatures. They are bound to overlap from time to time. Moreover, the British Parliament, when enacting the Indian Constitution Act, had a long experience of the working of the British North America Act and the Australian Commonwealth Act, and must have known it is not in practice possible to ensure powers entrusted to several legislatures will never overlap. And then down towards the bottom of page 43, he says, but the overlapping of subject matter is not avoided by substituting 3 lists for 2 or even by arranging for a hierarchy of jurisdictions. Subjects must still overlap, and where they do, the question must be asked, and in that context, what in pith and substance is the effect of the enactment of which complaint is made, and in what list true nature is likely to be found. If these questions could not be asked, much beneficent legislation would be stifled at birth, and many of the subjects entrusted to provincial legislation could never effectively be dealt with. In my submission, the purpose test was intended precisely to secure that the powers of the Scottish Parliament would not be unduly restricted or stifled, because if by reference to the purpose of the provision it does not relate to a reserved matter, then for the purposes of section 29(2)(b), any impact on reserved matters is neither here nor there.
I'd just like to consider what you do say about 29.4. I mean, what you say is that 29.4b only obtains if the modifications to the criminal law only apply to reserved matters. You say if they apply as here across the board, then you're not through the 4B gate. Is that what you say?
But that's my primary submission.
Yes, well, I mean, let's just see how that works. I mean, there may be something in it, because only then, on the face of it, does it really make sense to say, well, what you're then doing is okay, so long as it's just simply to secure consistency. Whereas if it applies anyway to more than reserved matters, you almost by then beg the question. You've already, as it's applying more generally than merely to reserved matters, inevitably there's a consistency built in, so you don't add anything.
Well, indeed, my Lord. And perhaps I can illustrate what in my submission this provision is about in this way. And my Lords were, I think, troubled by the connection between the provisions in Schedule 4 and what this provision is dealing with.
Yeah.
Now, Schedule 4 is about making modifications to the law on reserved matters. So if one keeps that in one's mind and one asks, what is one thinking about when one has a provision which would otherwise not relate to reserved matters, but makes modifications of Scots private law or Scots criminal law, and which applies, and let's take it this way, and which applies to reserved matters. Let's take the example of the ordinary law of criminal procedure. Now, if you have a reserved offence, the expectation will be that the ordinary law of criminal procedure, which is plainly not a reserved matter, it doesn't relate to reserved matters, will govern the prosecution of the reserved offence.
I mean, you might suddenly have some change as to hearsay rules, which is going to apply to driving whilst disqualified equally with everything else. Okay, so...
Yes, but what this would prevent the Scottish Parliament from doing is amending the rules of criminal procedure specifically in order to make some special provision for reserve matters, unless the purpose was to make the law in question apply consistently to reserve matters and otherwise.
So if you had an alteration to the hearsay rule specially designed to apply only to the Road Traffic Act, that would be outside the boundary, would it?
Well, one is always cautious because one need to look at every measure on its merits. But if one were contemplating a provision which was targeted, as it were, targeted on a reserve matter in that way, then that's the sort of provision in my submission that Section 29(4) is concerned with.
So but that would be... I'm sorry.
No, please go on.
No, but that would be okay so long as, until you made that modification, it had been different in respect to the reserve matter and everything else, and you're changing it in order to regularise it, to make it uniform across the board.
Indeed, my lord.
So, I mean, if you had a rule, say, you couldn't use, I don't know, hearsay evidence in respect of driving whilst disqualified, but you could for everything else, well, then you could eliminate that anomaly, and that would be compliant with 29(4). Is that what you're saying?
Indeed, my lord. Yeah. The Advocate General puts the underlying policy behind this provision in his written case at paragraphs 17 to 19 in particular.
Could you give the paragraph again? 17.
Paragraphs 17, 18 and 19.
Well, he's he's dealing with Section 29(4) here.
He's dealing with Section 29(4), and he tells us the provision addresses two competing concerns. On one hand, Section 29(4) is a restriction on the powers of the Scottish Parliament to modify the laws that applies to reserve matters. On the other hand, it allows for such modification if its purpose is to make Scots private law or Scots criminal law apply consistently to reserve and other matters. Accordingly, it's both a restriction on the powers of the Scottish Parliament and an enabling provision to allow for such modification if its purpose is to make Scots private or criminal law apply consistently to both reserved and devolved matters. This means that reforms of Scots private and Scots criminal law do not have to be artificially limited to avoid making provision as it applies to reserved matters, so long as the provision concerned applies consistently to devolved and reserved matters, thus preserving the unity of Scots law. Section 29(4) is set against a background where common law crime and a good deal of statutory crime is not reserved, although there is also a significant body of statutory crime which is reserved. Section 29(4) avoids the need to create parallel laws on basic areas of reserved and devolved Scots criminal and private law. For instance, it could otherwise be argued that such matters as general principles of criminal law jurisdiction, the system of criminal courts, evidence, procedure and sentencing were all devolved only so far as they related to substantive non-reserved offences, and were reserved so far as relating to substantive reserved offences. All these matters, accordingly, would require parallel legislation of the United Kingdom Parliament and of the Scottish Parliament. Such duplication would be undesirable, but also, through differences in approach, could lead to the fragmentation of Scots law. Section 29(4) allows for this to be avoided.
So the spectre that's raised there and is answered, really, is having to design Section 45, for example, in such a way that it's expressly limited to devolved legislation,
yes,
and then having to go to the Westminster Parliament to pronounce or to enact an exactly equivalent provision which should be designed to deal with reserve matters.
Well, indeed, and of course one must bear in mind the practicalities here that officials who are and experts in matters of criminal procedure in Scotland are located in the Scottish administration and not, yes, although plainly the Advocate General has a body of expertise to draw upon, the policy makers in this field are in Edinburgh rather than in London.
Yes. I mean, the other solution, which I believe has been adopted from time to time, is to cut the Gordian knot by just sending everything off to Westminster and have them dealt with there. But that doesn't seem to fit very well with the idea of these matters being dealt with in the Scottish Parliament.
Well, indeed, my lord. And just to go on to paragraph 19 of the Advocate General's submission, section 29.4 enables the Scottish Parliament to legislate across reserved and other areas of law, provided the purpose of the provisions to make the law apply consistently to reserved matters and otherwise. Thus, the coherence of the Scots law can be preserved, but the Scottish Parliament cannot stray beyond that purpose to make special distinctive provision in relation to, for instance, the reserved matters of financial services or consumer protection. That's the preserve of the UK Parliament.
Is that the same point as you're making?
No.
I think it's different.
It's
quite different with respect.
Well,
your contention, as I understood, is, unless I'm mistaken, it is, you find a section which is out of line with everything else.
Yes.
And then you use this in order to bring it into line. But as I understand what the Advocate General is arguing, he's arguing more or less what we've got here. In other words, that you put the whole, you try to update and reform the whole of the law of Scotland, criminal law of Scotland, and this power allows you to do it without needing to go to Westminster to have a little bit done for reserved matters, which is a different proposition, unless I'm mistaken, from your proposition.
Well, I agree with. I agree that the Scottish Parliament should have the power to make across-the-board reform.
I'm glad you agree, but the question is, how do you fit it? I mean, what's your submission? I don't understand how you get that from your submission.
I mean, your case is that you don't get into 4 because this isn't a modification of Scots criminal law as it applies to reserved matters.
Indeed, my lord.
Because it applies not only to reserve. So you say you've got to read 4B as if it says applies only to reserved matters.
Indeed,
but the Advocate General would appear to take a contrary view, but say, even assuming, as he does, that it applies to all, whether or not reserved matters, it's still satisfied here for the very reason that it's applying across the board.
Well, indeed, my lord. I pointed, my lords, to the Advocate General's submission partly because I detect that he takes a different approach on, or may take a different approach on this subsection. But in my submission, the way he puts the policy, particularly in paragraph 19, is quite perhaps helpful. What one is concerned about is that the Scottish Parliament should not be making specific targeted legislation directed to reserved matters. Now, I say that the way one gets to that is simply by reading B in the way that my Lord Brown has articulated.
I'm not sure there's all that much between you on this point, because if you start off with the status quo being that there is consistency in the sentencing powers of a sheriff sitting in a summary court, yes, the question really comes down to, does the Scottish Parliament first of all have to pass one lot of legislation dealing with the sentencing powers when it's a reserved matter, yes, and then 6 months later say, oh look, now it's inconsistent, we've got to achieve consistency, yes, or can it do it in one go? I mean, it's really as simple as that, isn't it?
Well, I would hope the Advocate General and I would agree that it can do it in one go.
Well, the Advocate General certainly does, and well,
that's certainly,
I'm hoping that you don't
that's also certainly my submission. Well, it's a question of how one. It may be a question of just how one approaches that under Section 29.4. I mean, I say one isn't in 29.4 because this makes modifications of Scots criminal law generally, and not as it applies to reserved matters.
I'd like to take you back to Section 29.2b.
Yes.
Because, of course, that's the first thing you come to, and you were dealing with it yesterday. And I think, but I'd like to be absolutely sure about this, that you say that 2b, read with 3, only applies where it is clear that the purpose of the measure is to deal with reserved matters.
Well, purpose relates to reserved
matters, and that's purely and simple reserved matters.
Yes.
Only.
Yes.
Is that right? The word only isn't actually there, but is that what you're submitting? So that you get beyond B in a case such as we're dealing with here, you say.
Yes.
And that's why we're really concerned with subsection 4 in this case. But I need to be quite sure how you get past the stark prohibition in 29.2b.
Yes. I get past the start prohibition because I say the purpose of this, having regard to the purpose of this provision, it does not relate to reserved matters.
Because of the point you made to Lord Brown earlier, is it that if you look at the purpose, you say the purpose is to increase the sentencing powers and thereby affect a reallocation of business
Yes.
In the court structure.
Indeed. And I, of course, immediately accept that the legislation has some effects on reserved matters, such as these particular provisions of the Road Traffic Act. But that does not, in my submission, lead one to conclude that it relates to reserved matters.
It's really an interpretation of relates to.
It's about what
critical.
relates to.
Yes.
That's what's critical.
Yes,
Yes.
Absolutely, my lord. And I point to Schedule 4, which is built on the hypothesis that one can modify the law on reserved matters without the provision thereby being treated as relating to reserved matters.
And to understand relate to, you look to the pith and substance, do you? Of
Well,
what
you also looked at 29.3, don't you?
Well,
And
yes, of course.
29.3 is spelling out the modern version of pith and substance, whatever that means.
Indeed, my lord. 29.3 tells us that the question whether a provision of an Act of the Scottish Parliament relates to a reserved matter is to be determined,
Yeah.
subject to subsection 4, by reference to the purpose of the provision.
Yeah.
And so one is enjoined
Right.
to identify as a critical step in the analysis the purpose of the provision. And then one has to ask, is this purpose, does it relate to a reserved matter?
The trouble is that, I mean, yes, that's what you do, but it doesn't tell you what relates to. I mean, it doesn't actually. I mean, does it help you with the interpretation of what's meant by relates to?
Well, I think one could certainly say this, that it's not sufficient that the provision has effects on reserved matters, not sufficient that the law on reserved matters may be amended, possibly substantially. If the purpose is a devolved matter or a non-reserved matter, I'm going to come back to that in just a moment, if the purpose is a non-reserved matter, then if the purpose does not relate to a reserved
Then it doesn't relate to a reserve.
If
If it relates to a non-reserve matter, it doesn't relate to a reserve.
Yes. There's perhaps an important point there, because the structure of the Scotland Act provides a single list of reserved matters. It doesn't give us a list of devolved matters. No. But in my submission, it is very important when applying these sections not to be diverted by reason of the inevitable focus, because of that structure, on the relationship between the provision and particular reserved matters.
I think that was a deliberate choice. I think I'm right in saying the original Act, is it the 1978 Act, did it a different way round.
It put it the other way round.
It was rather difficult to do. It
Yes.
tried to isolate what had been devolved. And this is intended, I think, to be a more widely embracing devolution system.
But I think the point I'm trying to make, my lord, is that inevitably in an individual case such as this, one is focusing on the relationship between the provision in question, section 45, and a particular reserved matter. And it's easy perhaps to be drawn by that focus of the debate into an over-concentration on that effect, the particular effect on the particular reserved matter. And in my submission, it is important, in order to preserve the intention of Parliament as set out in the Scotland Act, to always bring oneself back to the question, what is the purpose of this provision? And taking this provision as an example, it has a purpose which is entirely general. It's not about road traffic offences. It's about offences across the board, whether reserved or non-reserved. And it's important in my submission not to allow the structure of the legislation and the inevitable focus of the forensic discussion in a particular case to
Section 29 wasn't put there to stop the Scots reorganising their criminal justice system.
Well, indeed, my lord. Indeed not.
So once you identify the purpose, then you can say, well, that is what it relates to. Subsection 3 tells you that.
Yes.
And if you find that you've identified a purpose which is, as Lord Brown has just said, which is dealing with the Scottish criminal justice system, putting it very broadly, then that isn't a reserved matter, and you pass the test for little b.
Indeed. Indeed, my lord. Perhaps there's one other point I should just make in relation to little b, because of course there are two questions one will have to ask in a particular case. One is the first, and Mr. Shedd correctly said there's no issue about it in this case, but I think it's right that I mention it so that my lords are conscious of the issue. One has to identify what the reserved matter is. And there may be cases where articulating the boundaries of the reserved matter may raise quite difficult questions. They don't arise in this case because in the particularity of the reserved matter that we're dealing with here, which is the subject matter of the Road Traffic Act and the Road Traffic Offenders Act, one is dealing in the Road Traffic Offenders Act with a statute which specifically deals among other things, with mode of trial and penalty, and indeed that's part of the long title. And that being the case, I don't seek to suggest that this Section 45 doesn't modify the law on reserved matters. I wouldn't. That's not any part of my submission. But it's important that I just mention to my lords that in other cases, difficult questions might arise in terms of identifying what the reserved matter is. Having got past that, one asks, does the measure relate to reserved matters? And we are told by the statute that we do that by reference to the purpose.
Supposing Mr. Wolfe, the Scottish Parliament, decided that the prisons were too full and therefore it was going to halve all the penalties available across the board for all offences, reserved and non-reserved. So just half the maximum. So that, would that, suppose it halve the possible penalty for a road traffic offence? Would that be all right?
I think the way I would answer that, and I'm going to deliberately be very cautious in suggesting definitive answers in relation to matters which are not.
No, but it's just to try and understand the
indeed,
contours of
I understand that, my lord. Well, I think the starting point is that one would have to look at the provisions of the legislation, and one would have to look closely at the purpose of the provision.
Well, it would be to halve it would be try and reduce the prison population in Scotland by halving the provision for imprisonment.
I mean, what's the point of reserving road traffic? Is presumably to ensure some measure of consistency across Hadrian's Wall, is it?
It must be, my lord, and I should say, as my Lord Hope observed yesterday, it's the precise contours of that reservation are currently a matter of discussion, including in a relatively recent government white paper. But the basis for the reservation must be that it's an area where the expectation is that there will be a common system.
Well, they're rather bizarrely, actually. The maximum punishment in Scotland is twice what it is in England.
Well, indeed, my lord, and I put some papers there's some paper material in the papers which explain how that came about. Of course, the Scottish Parliament has respected the structure left in place or put in place by the UK Parliament by in what it's done in the section.
Well, maybe the UK Parliament reserved it to ensure that it remained twice as offensive as Scotland.
But is the answer to Lord Rodger's question to be found by looking at Schedule 4, Paragraph 2, Subparagraph 3? Because we've got here something which could be said to be a rule of Scots criminal law in the sense that it is dealing with criminal offences which are being prosecuted in Scotland. And the way that subparagraph is worded indicates that there could be a rule of Scots criminal law which is special to a reserved matter.
Yes.
And if one was had a provision which simply head-on met this point of the penalty in the Road Traffic Offenders Act and said divide it in half or reduce it by 1/2, that would be arguably at least something which was special to a reserved matter.
Well, I'm going to contend to my lords that the penalties in the Road Traffic Offenders Act are not. They are rules of Scots criminal law,
yes,
although reserved, but they are not special.
They're not special
to a reserved matter, because there are many 6-month penalties.
Right. I mean, if you had a penalty, the only offence in the calendar which still had a penalty of whipping were driving while disqualified, then that would be a special penalty,
yes,
in a reserved area.
Yes, yes. If this was if it was an offence only applicable in reserved matters.
Exactly.
Yes.
Only in that one.
Exactly. Exactly. That's what that provision.
But other examples of the same sort of thing would be the current speed limits in the road traffic legislation, which is special to road traffic legislation, obviously, or alcohol limits. They would be caught by that part of the provision, would they? Or perhaps even earlier on in the analysis.
Yes, I think they might well be caught by that provision. They're rules of Scots criminal law, but they're not rules that have any application outside the field of road traffic.
Yes, I see.
So that might well be caught, and of course that's one of the areas which where the boundaries are currently possibly going to be adjusted.
I just wanted to, I've rather detained you, I'm afraid, in looking at section 29(2)b, but I think you've really said everything that you want to say on that.
I think I've really said everything that I
I'm just
want
still
to
waiting for my answer, Advocate Deputy, to the question I asked.
Yeah.
You suggested a wrong answer.
Yes. Well, I think if I put it this way, my lord, one would look intensively at what the purpose of the provision was. It might well be that if this was designed as a genuine measure of penal reform across the board, that might well be acceptable. And of course, Scottish ministers are responsible for prisons, so why should they not? Now, of course, if the UK didn't, in relation to particular matters, did not not satisfied with such a provision, there are mechanisms available to it to deal with the question. In particular, I have in mind, first of all, section 35
of the Scotland Act.
Scotland Act, 35(1)b. Where if a bill contains provisions which make modifications of the law as it applies to reserved matters in which the Secretary of State has reasonable grounds to believe would have an adverse effect on the operation of the law as it applies to reserved matters, he may make an order prohibiting the presiding officer from submitting the bill for royal assent. So the UK has a built-in protection. And of course, ultimately, the UK can enact legislation to amend any act of the Scottish Parliament. In relation to, generally, subject to Shule Convention in relation to non-reserved matters, of course. So I think the answer to my lord's question is, could well be all right, and as a genuine measure of penal reform, why not? And if it creates a problem for the United Kingdom, in relation to particular reserved matters, the safeguards are there.
Good, very much. That's what you wonder.
Just tell us something very obvious, paradigm example, something it can't do into the Road Traffic Act.
Yes, it couldn't repeal Section 103, for example, or particular provisions. For the Scottish Parliament to repeal, say, a swathe of the offences created by the Road Traffic Act, and to be doing that specifically,
but if it
would
says,
relate to reserved matters and would simply fall out at first base.
but if it says too many of our prisoners are people who have been driving whilst disqualified, so we'll reduce the available sentence from that for 12 months to a week. Is that all right?
Well, that raises really this interesting question about that one is looking at the purpose of the provision, and one might well take one might take the view, and I'm expressing myself cautiously, one might take the view that a provision which is targeted at a particular reserved matter might, on the face of it, the court might require some persuasion, if I put it that way, that the purpose of that provision was not relating to reserved matters, because the effect would be specifically directed to the reserved matter, and looking at it as a matter of analysing the text. I suspect that one might reach a conclusion that the purpose of such a provision related to reserved matter. But one would have to look at all the relevant materials, of course, the text and any relevant extrinsic circumstances. Can I hope if I've leapt through 29(2)(b), unless there's any other matter that any of my lords wish to raise on that, just make my short submission on 29(4), and it's just slightly out of order from Mr. Shedd, that my primary submission is that we're not in 29(4) simply because this is a provision which modifies Scots criminal law generally, and not as it applies to reserved matters. But in any event, part of the purpose of the provision is to make the law in question apply consistently.
A provision can't be, supposing you had a provision which referred specifically to both a statute in the reserve field and the non-reserve field. You wouldn't say that because it referred to both that it didn't relate to reserved matter, would you?
Oh, no.
Right. Yeah. Well, if the underlying objective here is to prevent the Scottish Parliament from, as it were, targeting a reserved matter, if it's passing a measure which applies consistently to both, then
it couldn't be the case that if you had one section dealing with the reserved matter and the next section dealing in identical terms with the unreserved matter, you couldn't come to a different result, could you? If you could achieve exactly the same thing by putting the both into the same.
And I can see, of course, that the point would be made that this provision could no doubt have been enacted by a whole series of sections specifically dealing with the whole raft of provisions to which it was intended to apply, and the result would have to be the same. One would look at each provision in its context, in the context of the enactment as a whole. And if what it's doing is making the law in question apply consistently to reserved matters and otherwise, then in my submission, one satisfies 29(4).
Does that mean if when you're looking at the 2007 Act, for example, you start off with Part 3 headed penalties, a sort of subheading is sentencing powers, And it could have been structured with Section 45 dealing with offences in the Scottish Parliament, and then it would be a 45A or whatever it was dealing with specifically with reserved matters. But you say, look at the overall context, and the fact it's in a self-contained provision isn't the end of the story, because you get the purpose by looking at the whole group of sections.
Indeed, my Lord. Or indeed, if Section 45 had increased penalties by reference to a schedule which listed every enactment, whether subordinate or primary, whether Scottish or Westminster, whether reserved or non-reserved, the result would have to be the same. I entirely accept that.
Just while we're looking at subsection 4 in 29, I'm looking at paragraph A there, which says a provision which would otherwise not relate to reserved matters. Is that just a reflection back to 29.2b? So that it's saying, well, if you've said no to that, you're still having to look at 29.4.
Indeed, my Lord.
So the interpretation of 2b is the same as 4a.
Yes.
Again, you're looking at the purpose all the way through.
Yes, you only get to 4 if the measure has satisfied is valid under 2b.
Well, you say valid under 2b. I mean, 2.4 in part tells you whether it's valid under 2b, because at the end of 2.4 is a question of whether you're treating it as being relating to reserved matters and therefore invalid under 2b.
Yes.
Yes, that point is made very clearly by the Advocate General in the passage you showed us. That 29.4 has a double action, and it starts off by extending subsection 2, but it then has a let out.
Of course. No, and that's absolutely correct. But of course, what one can take from 29.4 in relation to 29.2b is that it's implicit in 29.4 that modifications of the law as it applies to reserved matters, modifications of the law as it applies, that the law may affect reserved matters without being treated as relating to it. Schedule 4, paragraphs 2 and 3. I accept that Section 45 modifies the law on reserved matters. My submission is that...
We're looking at which part of...
Sorry, Schedule 4, paragraph 2.
Yes.
Subsection 1. I accept that Section 45 modifies the law on reserved matters.
I see, you accept that for the purposes of the schedule, but not for the purposes of 29.4.
No.
Do you really? Because it does not depend what's meant by the law on reserved matters.
Yes, and we're told that in paragraph 2a, that the law on reserved matters is any enactment, the subject matter of which is a reserved matter, and which is comprised in an Act of Parliament or subordinate legislation under an Act of Parliament. And the Road Traffic Offenders, the subject matter of the Road Traffic Offenders Act, it is a reserved matter.
Subparagraph 1 applies in relation to a rule of Scots private law only to the extent the rule in question is special.
Well, indeed, what I'm saying is 2.1 is disapplied by 3, is my submission.
No, it's not. Your position is that it doesn't. In terms of Section 2.1, it doesn't modify. It doesn't. It's not caught by 2.1.
Oh, it's not caught by 2.1. It's not caught by 2.1.
And that's because of 3.
But that's because of 3.
Yeah.
And I accept if it were not for 3, 1 would be in 2.1.
Yeah.
Sorry, Lord, I didn't make myself clear. I say that we're not dealing with a rule which is special to a reserved matter. And I say in any event that we're in 3 because the effect on, or the modification effected by Section 45 on the particular provision we're dealing with here is simply an incident of the provision which itself does not relate to reserved matters.
So when you say 3, you mean paragraph 3 and not subparagraph 3 of paragraph 2?
I beg my Lord's pardon, yes, paragraph 3, not 2.3.
Sorry, I'm lost now.
I beg my Lord's pardon.
We'll just have it again. So just have it again.
I say paragraph 2, the prohibition in paragraph 2.1 does not apply.
Right.
And I say it does not apply because of subsection 3 of paragraph 2.
Yes.
Because we are not dealing with a rule that is special.
Yeah.
Yeah.
I also say, or I say, if I'm wrong in that, in any event, paragraph 2 does not apply because of 3.
So it's just a fallback.
It's a fallback. It's a fallback. Because we're dealing with something which is incidental to the provision and which doesn't have a greater effect on reserved matters than is necessary to give effect to the purpose of the provision. It does to the reserved offence precisely what the purpose of the provision.
I understand you to say you don't need to get to 3 if you come out under 2, 3.
Indeed, my Lord. And I should say that it may be that particularly 3b, one could develop a submission on 3b, and there may be cases where 3b, one needs to consider carefully the nature of 3b and...
3b is which?
Paragraph 3.
3.1b.
3.1b.
1b, sorry. Yes,
3.1b.
Yeah.
Where we're talking about modifications which do not have a greater effect on reserved matters than is necessary to give effect to the purpose of the provision. And my Lords may see an echo there of the an aspect of the proportionality analysis that one gets in convention rights cases. And in a case where the issue arose perhaps a more complex way than here, one might have to consider necessity by reference to the purpose of the legislation and the extent of the restriction. And one might have to consider the extent to which there's an area of discretionary judgment to be allowed to the legislature, the extent to which the court substitutes its decision. In my submission, those interesting questions don't really arise in this case, because I think it's plain that this provision, the modification it makes, is no more than is necessary to give effect to the purpose.
In broad terms, Deputy, I understand the position to be that what we're dealing with here is a situation where, in general, the Scottish Parliament can legislate on matters of Scottish private law and Scottish criminal law.
Yes.
But there are 1 or 2 rules which are absolutely special to matters which are reserved. And in that area, the Scottish Parliament can't intervene.
Yes.
And except to the extent that it might be incidental to,
yes.
And that's paragraph 3. But they can't, if there's a special rule, for example, to do with bills of lading or something like that, they can't go in and deal with that matter of Scottish private law. That's an exception from,
yes.
from there.
Indeed, Lord. And the logic of that is that where you have a special rule which is applicable only to a reserved matter, then there's a logic to treating that as part of the corpus of law applying to the reserved matter, rather than as part of the generality of criminal or private law. My Lords, for all these reasons in my submission, the issue in the case falls to be answered in the affirmative. If my Lords were to be against me on that, certain consequential issues would arise, which I address at paragraphs 60 to 64 of the case. And the first one is a question of reading down, or perhaps more appropriately, severance.
And that's applying section 101, subsection 2, is it?
It's applying section 101, but more importantly, in my submission, it's applying section 29.1.
Yes.
and in particular the words so far as.
I see.
An Act of the Scottish Parliament is not law so far as any provision of the Act is outside the legislative competence of the Parliament.
Yes.
And in my submission, that implies that where legislation is defective by reason of being overbroad, that legislation should be read as applicable only to those cases which may lawfully be covered by it.
So you narrow it down to apply only to either way offences which are to be found in Acts of the Scottish Parliament?
Well, no, my Lord, because of course there are the distinction is not between Acts of the Scottish Parliament and Acts of the Westminster Parliament, but between reserved and non-reserved.
Yes.
And there are Acts of the Westminster Parliament which deal with reserved matters, which are still on the statute book. Criminal Procedure Scotland Act 1995 is a good example. The words "so far as" permit, and of course this only arises if the court has found that otherwise the Act would, or the provision would be ultra vires, that the court may read the provision in a way so that it only applies to those matters which it may lawfully apply to. My Lord, that approach...
Sorry, hold it. I mean, is it only the Road Traffic Offenders Act which is a reserved matter to which Section 45 applies?
There may be others, my Lord. There are other reserved offences which will have been affected. I don't have a list of them, I'm afraid, but it's not restricted to the Road Traffic Offenders Act.
Sorry, so I mean, aren't we looking at Section 101 at this point then? I mean, on this hypothesis.
Yes, it's 101.2, but read along with Section 29.
But I mean, so you have to read 45 as if it says what it says, but excluding given acts, given either way offences which are reserved. I mean, and that's a reading that's possible, is it?
Well, my Lord, I found on Section 29.1, it's perhaps a different point. It's perhaps not so much an interpretation point as a reading of 29.1, that an Act of the Scottish Parliament is not law so far as any provision of the Act is outside the and it's the word "so far as" any provision of the Act is outside the legislative competence of the Parliament.
I follow that, but I mean, you can't ignore 101.2, can you? I mean, you can't simply bypass the apparent problem in 101.2, can you, by just simply saying, well, it wasn't competent, and therefore it's not law, and therefore we can ignore it. I mean,
well, this approach is one which commended itself to the Court of Appeal in Northern Ireland, considering the Government of Ireland Act. In a case, the Ulster Transport Authority, which is in Volume 3 at tab 44.
Oh, did it have a provision equivalent to 101.2?
I don't know that it did, my Lord, but it had a wording similar to 29.1, and in particular the phrase "so far as."
Sorry, what is it? Bundle 3 or?
344.
44. 44.
But you have to construe the provision you're looking at,
yes.
don't you?
Well, everyone agrees, I think, my Lord, or as I understand it, my Lord, that the provision, the obvious reconstruction of the provision is that it applies across the board. And I simply offer this as a mechanism whereby one doesn't throw out the good with the bad, if there is any bad. I don't accept this as bad, but if there were any bad here, and one is looking for a mechanism to preserve the good.
All I was passing through my mind, and maybe I'm making the same point as Lord Brown, is one would say, yes, you can read the provision as applying, as within competence, because read with the assistance of Section 101.2 1(2), you can read it as applying only to devolved matters. It's rather an extreme way of doing it, but it would be that it doesn't extend to statutes which are reserved.
Yes.
Of which there may be quite a number when you start looking down Schedule 5 at all the list of things like drugs and so on.
Well, indeed. Well, that would be one way of approaching it, and it would be supported by the word so far as in section 29, which in my submission do allow for what's been described as horizontal severance as well as...
Yeah.
But your primary submission, as I understand it, is that section 29(1) is dealing with severance, saying you discard the bad and left with the good.
Indeed.
Section 101 is concerned with construction.
Indeed.
And it may be a very special rule of construction, like section 3 of the Human Rights Act, but there comes a point at which you say it's not possible to deal with it as a matter of construction.
Yes. But I say that 29(1) allows one
You do.
to engage in the severance exercise. And I point to
Yes, I see.
the Irish case, Ulster Transport Authority against James Brown and Sons Limited, where the tab 44 in volume 3, and it's at page 118 of the report, where the Lord Chief Justice, Lord McDermott, looking precisely at a very similar wording in the Government of Ireland Act, said that as well as this vertical severability, if I may describe it, I see no reason why the circumstances warrant such a course. The terms of section 5(1) should not be sufficiently met by what I may call a horizontal severance, a severance that is which, without excising any of the text, removes from its ambit some particular subject matter, activity or application. This, I think, would give effect to the word so far as it contravenes, without impinging on the meaning or weight to be attached to the word void. And
yeah, so can I just see if I've got this in my mind, that if you can engage in the exercise of severance,
yes.
Then you don't need to look at particular words, you simply sever.
Yes.
But there may be, you're left with a word which has to be interpreted, which you can't sever out, but have to interpret, and that's where section 101 would come in. Yeah. Is that the way it works?
Well, there may be two ways of getting to...
You not interpret first, and then if necessary...
if necessary, sever.
Sever.
Yes, I mean, it's like under the Human Rights Act, you go to section 3 first, and then you go to section 4. And
yes, that must be right. That must be right. So you engage in the 101(2), and one could read it in the way that my Lord Hope has suggested. But if one can't, if by the generality of the language one feels one simply can't read in the qualification, the answer is in 29(1). Enacted in light of that, the authority from Northern Ireland. And my final fallback point, my lords, I'm afraid, is a section 102 point about suspension and retrospectivity. I make this point because my lords will recall that one is dealing here with an enactment which has been in force now for a period of time. Sentences will have been passed in reliance on that enactment. We are not dealing with any challenge to that touches on the substance of a conviction or on the level of any sentence or on the maximum sentence that would have been available. And in any case where a sentence has been imposed which has in fact been excessive, that will have been capable of being appealed and dealt with in the ordinary way. And my lords, in those circumstances, in my submission, there would be merit in my lords making an order, if my lords get to this point under section 102, confining the retrospective application of this of such a decision, so that it doesn't affect any case other than these appellants, or any case which has been finally determined.
Well, the way you put it in paragraph 62 of your case is limiting the retrospective effect of the decision to the 2 current cases and any other cases prosecuted in the courts which are still pending or have been determined.
Yes, and I think I would also allow any case in which the very short statutory time limit for appealing the sentence under the ordinary rules for sentence appeals has not expired. And I offer that because I recognise that in issues of questions of this sort, there will be a balance to be struck between upholding the law and not opening up, not as a result opening up already decided cases.
So you say it should be limited to whom? To whom? This pair, obviously, but who else?
Yes, if my lords get to this, an order limiting the retrospective effect to the 2 current cases, to any other cases which are still pending before the summary courts or the appeal court, and to any case in which the very short statutory time limit for appealing has not expired. And that's the statutory time limit, I think, in section 186 of the Criminal Procedure Scotland Act.
Sorry, I'm not sure I'm really quite following. I mean, how does it actually work? I mean, on your 2 clients, does it eliminate their sentences altogether, or does it cut them to 6 months?
Well, on disposal, my submission would be that if the appellants were successful, that this court should remit the matter to the High Court with instructions to pass the bill and remit to the Sheriff for sentencing. Because there may be issues, Mr Brown mentioned issues around the plea of guilty, there may be issues that make it slightly more complicated than my lord simply cutting the sentence down.
Because you mean if it had originally been a maximum of 6 months on summary disposal, well then he maybe wouldn't have got the full 6 months.
Lest there be any particular factual quirks here, I'm quite content the matter goes back to the...
But it wouldn't be open to the prosecutor to say, well, we think we'll have you on indictment after all, would it? Or would it?
No.
Why not?
They've sold their size, my lord.
All right. And in the outstanding cases, then the question, you say a case is still pending, well then the sheriff's going to be told, well, presumably there's already been an election for summary disposal by then.
Yes.
And so the sheriff simply told, well, you're back to your old maximum, 6 months. Is that it?
I thought you said the reverse.
Huh?
Sorry?
So I thought you were giving them the benefit of it.
Yes, I recognise...
Why are you giving them the benefit of it?
Well, I can see that the logic of the fact that they were not actually changing any maximum sentence would be that one simply, perhaps rather than limiting the retrospective effect, one might simply suspend the effect of the order to allow the matter to be put right if and I think it would have to be the Westminster, the United Kingdom, were prepared to do so. I mean, that would be the alternative way to approach it, simply to suspend the effect of any order in order to allow the United Kingdom, if so advised, to put in place a mechanism whereby the matter could be corrected.
Sorry.
I would have thought that really was the primary purpose of section 102.2, really,
Yes.
to enable that kind of thing to be done.
Yes. And I suppose if there, in this case there would be some substantive merit in it, because one is dealing with something which doesn't touch on the merits of the case, which doesn't touch on the maximum sentence available, and which and where, if there has been an excessive sentence, it could have been appealed. Sorry, my lords, I've perhaps not been as formulated this very well. Perhaps my primary position should be a suspension to allow that to be done.
Well, that fits with section 102.2b, the concluding words, which is suspend to allow the defect to be corrected.
Yes. I think what I would have to recognise in the case that we're hypothesising is that any correction would have to involve the United Kingdom. Now, that might be done by the United Kingdom passing an order which...
Is that section 107? Is that where it comes in? That's what I was looking for. Where did it come?
Yes. I think I'm right in saying
I'm asking. I mean,
yes.
it's
Sorry,
curiously imprecise as to who's doing it. But,
yeah.
I think it would have to have the United Kingdom body.
I think that's right, my lord. And since the essence of the problem is a trenching on reserved matters, so I think perhaps my primary position should be a suspension of the order to allow that at least to be considered, which failing a limitation on the retrospectivity of the provision.
So how does it affect these two appellants?
Well, I'm reluctant to... I mean, if it were a suspension, I suppose they would lose the benefit of their appeal. And
I think that would be... I think
it might be contrary to the Human Rights Act for the Westminster Parliament to pass such a statute. And
well, there are interesting questions about retrospectivity which arise. I mean, I think this court might have to do something in that regard. Now, I recognise that it's hard to deprive appellants who have been successful, where the issue is the lawfulness of what's been done, of the fruits of their efforts.
I mean, but other people who haven't taken the point don't get the benefit.
Shouldn't get the benefit.
If people have lodged bills, as sometimes people do, lodged challenges formally in order to piggyback onto the thing, then they may or may not get the benefit. But other people who haven't don't.
Well, they shouldn't, in my submission. And that's really what I'm inviting the court to do by way of an order under section 102.
Yes.
And my submission on disposal is that if my lords are with the appellants, it should go back to the sheriff. If my lords are with me, I would also invite my lords to refuse the appeal, but to remit the matter back to the High Court. And I do that because if the appeal is refused, issues of seeking a warrant to arrest these two appellants will have to be dealt with, and I don't wish to trouble my lords with any question relating to that.
Thank you.
I don't know if I can help the lords further.
Thank you very much indeed. Mr. Muir, do you wish to add anything?
Well, I have nothing to add.
Thank you. Advocate General.
The time that I estimated for this submission has, of course, been dramatically shortened as a result of the approach adopted by the Advocate Depute. I would say I adopt substantially the interpretation proffered by the Advocate Depute in relation to the interpretation and application of Section 29 in Schedule 4, and fully support the conclusion that the respondent offers in her case. There's perhaps little to add on that area. One of the points that had caused me to consider that this might be a rather more lengthy submission than it was the way in which the respondent had set out in her case a substantial assessment of the constitutional position as it's described, and this in the case between paragraphs 20 and 40, substantially, from the Lord Advocate. Now, Lords, I suspect I'm not in a quandary, but the way I would look at it is this. Lords have not been addressed on these issues orally. They are, however, set out substantially in the statement of case. Now, I would not wish my lords to think that what appears in the statement of case is accepted word for word by me. Given that there has been no oral submission in support of these propositions, I assume that these are not being substantially advanced at all. If perhaps I can briefly indicate where there might be areas of difference, these will be found in relation to the observations about constitution at paragraph 20 of the Respondent's case.
No, just wait a moment. We've got two cases. We've got Martin and Miller. Are the paragraphs?
They're identical.
They are actually.
The numbers are slightly different.
Because
Right.
I think your numbering differs slightly.
Martin would be the
So we
one
take
that-
Martin, do we? Yes. And we begin at paragraph 20, because 19 is not contentious, I think. That's just simply telling us what we need to look at. And I think you said on to paragraph 40, but that seems to go rather further than
Yes,
would be right, because
within that area, from 20 to 40.
the 29 is dealing with section 29(2)(b). And that's really into the meat of the argument. So can we just be quite sure what it is that you want us to excise from your general agreement?
Well, specifically, Lords, in paragraph 20, there is a discussion which appears to suggest, and I'm speculating to a degree, but what it does suggest at E to F is that the Scotland Act is to be regarded as a constitution. Now, I can develop that a little more if my lords would wish, but given that there hasn't been argument...
I doubt whether it's going to help us very much, because I think it's common ground between the appellants and the respondent that what we're really looking at is the wording of the statute and applying it.
That, of course, is the position set out in my statement of case. It is simply in response to what I read in the statement of case. And I'm really making this submission of maiorem cautelam, that it not be taken as acceptance passively by me in relation to what is set out here. If perhaps then I just go through the references. Paragraph 20, paragraph 27, again appears on one reading to suggest that one should treat, this at the beginning of paragraph 27, that one should treat the Scottish Parliament like other legislatures which have been created by the Parliament of the United Kingdom. Now, I will not trouble the Lords at length, but the notion that the Scottish Parliament is to be equiparated to the Canadian or Australian parliaments through constitutional acts, I would take issue with. In relation to paragraph 24F, I'm sorry if I'm jumping about, again, I'm not entirely clear, but there seems to be some suggestion that a combination of the Sewell Convention and the Memorandum of Understanding between the UK and the devolved administrations in some way adds to the legislative competence, or the ambit of the legislative competence of the devolved administration.
Sorry, which paragraph?
24F, my lord. It's found at page 22 of the...
We're going back.
And I would simply draw my lord's attention to the fact that the Memorandum of Understanding itself sets out that it is a non-binding agreement. therefore it would seem unlikely to in some way extend or have a direct impact as a matter of law on the Scotland Act. And perhaps outside that sort of general area, the other point I would maybe take issue with is at paragraph 57, and in relation to the discussion about the use of the word necessary in paragraph 3 of Schedule 4. And again, this perhaps goes a little further than I might necessarily accept, because it goes on to talk about a degree of latitude being accorded to the Scottish Parliament and the Advocate Depute in dealing with this particular area proffered the notion of discretionary judgment of the Scottish Parliament. Well, I would argue that necessary does not actually have a meaning that suggests a wide range of latitude. But as I say, this has not turned out to be a discussion. It's simply for the greater caution. In relation to disposal, I would broadly agree with the approach suggested by the Advocate Depute. But to the extent that this should be sent to Westminster for the curing of defects, I would share immediately with respect my Lord Walker's observation that this may well have significant European Convention consequences and would require to be looked at very closely, and it should not be taken in any way. I'm assenting to the notion that in some way Westminster would simply set about curing what is described as a defect.
So are you really indicating that if it came to this, you would need to reserve your position as to exactly how you would deal with the problem?
If it were to come to this, my Lord, yes.
Is that in relation to the retroactivity?
My Lord, yes.
I mean, there would be no objection on the policy of...
No, my Lord. It's simply the question of how this would have impact where, if something were not law, how this was going to affect people who had been convicted under not law. Lords, beyond that, I have nothing further to add.
On anything?
Unless the Lord wishes me to.
Well, I'm sorry. I mean, I'm not sure. Are you and the Advocate Depute at one on section 29(4)? Well,
there plainly is a difference of emphasis, but the outcome, the result to which one comes is, it would appear, essentially the same, that one is trying to find consistency as the guide between reserved and devolved matters. And that is where section 29(4) seems to add to 29(2)(b). But my Lord has the...
29(4) adds quite a lot to 29(2)(b). Does it not?
Indeed, my Lord. It expands matters.
Your point.
Yes. But it expands matters which are reserved, that's clear. And therefore suggests that there is a limit on, I suggest, on the Scottish Parliament's competence.
But it expands provisions which relate to reserved matters, doesn't it?
Lord, yes.
Class.
And therefore, that's why I say it reduces the extent of the competence of the Scottish Parliament. But the proviso directed towards consistency is to achieve effectively the same result as my Lord friend puts it across the board.
But I mean, sorry, do you say that if it applies across the board, and merely includes within it a modification of Scots criminal law as it applies to a reserved matter, by definition it applies consistently to reserved matters and otherwise, because then, then nothing is added.
Well, no, the consistency has to be between both the reserved and the devolved matters. So again, when one's trying to give content to the purpose of the provision, it's defined as here.
I mean, I'd find it enormously helpful if you bring it to life by an illustration where you've got into subsection 4, you've reached a point where it wouldn't otherwise relate to reserved matters, having regard to subsection 3 and purpose and all the rest of it, but it does make modifications, etc., and then I would like an illustration of how A, it fulfills the proviso, and B, it fails to fulfill it with the result that it extends 29(2)b. Can you give us an illustration?
Well, I share the Advocate Deputy's caution in going into this type of area.
I mean, take it.
The trouble with, Lord knows that producing examples on one's feet is not necessarily the best way in which to guide understanding of the process of prosecution.
Do we have to just make them up for ourselves? Do we try to dream them up? I mean, it's very difficult because, I mean, we've got to interpret this. And somebody did draft it and was presumably thought it meant something. It's not very helpful not to be able to be told that there's any example of when it would work.
Well, I take that observation, my Lord.
No, are you able to enlarge on what the Advocate Deputy was?
Not usefully, my Lord.
Oh dear. Simon happy.
Oh, sorry.
Thank you very much. Well, Mr. Shedd, I think you have an opportunity to reply. Mr. Brown, it's right to say, would have too. So shall we take you first, Mr. Shedd?
Yes, of course, Madam Obliged. Well, I wonder if I could take up the point discussed by the letter very briefly in terms of section 102, and also identified by the letter that general in his submissions to the Lordships. I would respectfully ally myself to the general's identification of potential concerns in respect of the all that position notes on that matter. So far as the learned advocate deputies,
I think you probably need to switch on that thing there. Not for our benefit, because it doesn't help us, but it might help others.
I'm sorry. So far as the learned advocate deputies' suggestions, your lordships, in relation to the disposal of the bill of suspension, if the appellants were to prevail, then in my respectful submission, there's force in that proposal, Lord, so far as the appellant whom I represent is concerned, because there are matters other than the mere competence of the sentence which might be best resolved again by the sheriff in due course. And of course, my lords, should for any reason the sheriff impose a sentence which might arguably be regarded as excessive, that would preserve any conventional right of appeal from the decision. So, if I may say so, my lords, I can see force in that proposal, if your lordships were otherwise with the appellant.
Yes.
My lords, therefore, I would, if I could just raise one or two matters which seem to have emerged from the discussion. Lords, obviously the primary position for the appellant, as sought to be articulated yesterday, was that 29(2)b is applicable in this particular case. I seek to emphasise that, my lords, only by reminding my lords of the reach of section 45, subsection 7. And I'm inviting my lord's attention, of course, to the fact that your lordships are enjoined to look at the question of effect in ascertaining purpose. And I'm respectfully emphasising to my lords that the starting point in this particular instance is to focus upon the question of legal effect. And that's why I say to my lords that section 45, subsection 7 is relevant to that analysis. And I would respectfully submit to my lords, not, I hope, repeating what was said earlier, that that should bring out the conclusion contended for. My lords, in my respect,
those words should bring out
the conclusion that the appellants contend for, my lord, in relation to 29 2b. The Lords were also discussing with the Learned Advocate Deputy the question of Schedule 4 and whether a provision is special to reserved matter. My Lords, the submission for the appellants, I think effectively jointly, was in respect of the observations which were made by Lord Sewell, which are set out in the excerpts from Hansard and are conveniently summarised at paragraph 56 of Mr Miller's printed case. And I would respectfully invite my Lords to the view that there's some force in those, contrary to what the Learned Advocate Deputy contends for before your Lordships.
Now, what's the point you're making?
Well, the point...
Paragraph what of whose case?
56, my Lord, of Mr Miller's case conveniently sets out the passage.
This is Lord Sewell's examples you're directing us to.
And his explanation for any assistance it may provide your Lordships that matters which are special to reserved matters are those which result in a distinct and separate treatment of a reserved matter. And I respectfully submit, if your Lordships were to consider that that was a useful way to look at the matter, then it again...
well, we're looking at the examples as well. I mean, you know, it doesn't look like much like the Road Traffic Act to me. A penalty in the Road Traffic Act. I mean, Lord Sewell is referring to specific things under Copyright Design and Patents Act there, a special form of assignation which doesn't occur anywhere outside that act. Well, whereas we're dealing here with the penalty, which, you know, is it special?
Well, Lord, I appreciate the question your Lordship has to address is the one where the word is to construe the words specifically in the schedule, rather than necessarily accepting observations which are made in the course of the debate. But nonetheless, Lord, if the matter were to be viewed, as Lord Sewell suggests in my submission, it would bring the appellants within the scope.
Lord Sewell's examples suggest to me what he's meaning. He doesn't. I don't understand. I mean, these examples look to me, and it goes on to deal with the sponsor ludicrous doctrine relating to betting and gaming, and so a matter which is unique to a reserved area. That's as I understand it.
Well, Lord, I fully appreciate if your Lordships have come to the view that that's the proper interpretation. I see the appellants have been difficulty in relation to that.
I just don't understand how this helps. Is it just? I mean, I don't understand how this passage helps you. I think that's. I mean,
yes, I'm obliged, Lord. It's simply the description applied to and the exposition of what special might mean. In my respectful submission, applying those words can be applied in the context which is contended for by the appellants. But, Lords, I don't think I should perhaps press the matter. Lords, however, the position, Lords, in answer to the questions I think both my Lord Brown and my Lord Rodger raised with the Learned Advocate Depute about the hypothetical situation of the Scottish Parliament seeking to reduce the penalties are nevertheless, in my respectful submission, apt questions, because my Lords are starting from the position that the Scottish Parliament cannot legislate in respect of reserved matters. And in my respectful submission, in the stark examples that your Lordships put to the Learned Advocate Depute, then the position would be that the Scottish Parliament would be acting beyond its competence. Because your Lordships are concerned with a matter in this context of a penalty under the Road Traffic Offenders Act, but it's comprehended within the scheme of the legislation.
And by stark example, you mean reducing everything down to 1 week's penalty? Is that the kind of thing you...
Absolutely, Lord. Because the situation is that Parliament, in enacting the Scotland Act, has very specifically prescribed reserved matters which are not to be legislated upon as a generality by the Scottish Parliament. Now, Lords, that happens to extend in my submission to the Road Traffic Offenders Act and the penalty provisions in the Act. It goes as wide as that in my respectful submission. So that's the starting point. And therefore, in my respectful submission, the questions which your Lordships posed are useful ways to analyse the matter, and the answer to them would be, in my respectful submission, that they were such legislation would be beyond the competence of the Scottish Parliament.
Yes.
Now, something, Lords, was also made of the question of the unfortunate practicalities of the potential for parallel legislation. But of course, Lords, in my respectful submission, that may be to miss an important point, which is Westminster Parliament has decided what the relevant penalty is in respect of the Road Traffic Offenders Act. And it's therefore for Westminster to decide, in my respectful submission, whether the penalty be increased or reduced. So it may be, Lords, that there would be no question, as it were, of administrative inconvenience because it's a matter which properly resides in Westminster.
Just help me, I mean, matters such as release on licence, parole, all that sort of stuff, is that devolved or reserved? I mean, who decides when people actually get out of jail in Scotland?
Lord, it's in short-term sentences in Scotland, if I remember correctly, Lord, that's custodial sentences of less than 4 years. There's an automatic release after serving half of the sentence. In sentences which are 4 years or more, the question becomes a matter in due course, in some instances for the Parole Board for Scotland. And these are, as I would understand it, Lord...
That's in UK legislation, which relates to Scottish criminal procedure. Is that,
yes.
Is that the broad heading under which it would come?
Yeah. Yes, absolutely.
And of course, it just reflects on penalties too, but there's a procedural mechanism. How would you categorise it?
Well, it's a matter which is regulated, Lord, if my recollection serves me properly, by statute, which was a statute enacted by Westminster, which governs the release provisions.
It's devolved, really, to the Scottish.
Whether it's enacted by Westminster or not is totally irrelevant, actually. It's a question of whether it's devolved or not. And surely the answer is that it is devolved, isn't it?
Yes, it is.
The Scottish penal system must be a devolved matter.
Yes, it is.
So, I mean, if Scotland wanted to let everybody out after having served a third of their stipulated sentence, it could.
Yes, as a generality, my Lord, but that's not, my Lord, I think the tension I was seeking to identify. In this context, I'm only pointing to the fact, Lord, that the penalty in the Road Traffic Offenders Act is regarded by all as a reserved matter, and therefore, on the face of it, it's a matter for Westminster to decide whether that penalty be reduced or extended. And in my respectful submission to your Lordships, that is a useful way to look at the question raised with the Learned Advocate Deputy as to whether there would be a need for a parallel legislative provision. All I'm respectfully saying to my Lords is the matter would revert to Westminster, and Westminster could decide whether or not any change was appropriate. So, my Lords, those would be the brief supplementary submissions I wish to make. Thank you, my Lords.
Thank you very much. Mr. Miller.
My Lords, if I may simply take up where my learned friend Mr. Shedd has left off.
Yes.
Penalty in certain circumstances is a matter that is reserved, as I would submit obviously in relation to the Road Traffic Offenders Act. The management of that penalty is indeed a matter which is devolved. And I simply touch on this given that there has been some reference to the potential for sentence drift as a matter, I think, of common knowledge, certainly north of the border. The prison population, despite the efforts that were referred to yesterday by the Learned Advocate Depute, has increased, notwithstanding diversion from prosecution. So it may be that there is an implicit sentence drift in the raising of the prison population, which is perhaps bolstered by the fact that as a matter of administration of sentencing, the Scottish Prison Service is releasing earlier than provided for in the Prisoners and Criminal Proceedings Scotland Act, the Westminster legislation my learned friend was referring to, which allows release at half of service of a sentence under 4, but in fact is now allowing release after half of a half, subject to certain risk contingents. But that is a matter of simply background. I say that, my lords, because in my respectful submission, as accepted by the learned advocate depute, the crucial issue before your lordships is the words of the statute. In that regard, in my respectful submission, essentially, the learned advocate depute must concede that his implied only in 29(2)b is not a path your lordships should follow. The real issue, in my respectful submission, is the interpretation of section 45(7) of the 2007 Act. Reference has been made this morning to the modern version of the pith and substance, and of course that was referred to by Lord Sewell. He also made reference in the passage in Hansard, which your lordships have seen, to respection. And in my respectful submission, it would be of benefit for your lordships in assessing this matter, simply having to have regard to the passage in the written submissions for the Appellant Miller at paragraphs 41 and 42, where Lord Chief Justice...
So paragraphs 41 and 42 of what?
Of the written submissions of Miller, my lord, the core volume, tab C.
This is quoting from Hume.
Yes, which makes reference to Calvert.
Yes.
And the fact that the Gallagher and Lynn test is two-part, is the enactment in respect of a matter within the authorised field, and does the enactment purport to legislate in respect of a forbidden subject or subject, that is to say, in respect of some subject matter outside the authorised field? It's the second test of Gallagher versus Lynn. In my respectful submission, that is the nub of this matter, and in my submission, section 45(7) is caught by the second leg of the test. Yeah. And finally, my lords, in relation to subsection 29(4), I simply reassert that the words of the statute, which are the important matter, are that a modification is allowed to Scots law as Scots law applies to reserved matters, not modification of the reserved matter itself. Obviously, to conclude, my lords, some reference has been made to section 101 and 102. I have nothing to add to that save a factual correction. The learned advocate depute made reference to the time limit for statutory sentence appeals, yes, which is short. Yes. Properly, of course, for an issue like this, which is competence, the vehicle of appeal is bill of suspension, for which there is no time limit.
Well, we're very grateful to counsel for their submissions in writing as well as orally, and so the expression of gratitude extends to those who are responsible for the written material as well as those who have addressed us these last 2 days. The court will take time to consider its decision.